sure that there will be public issues in काम आ रही people ही आएंगे
इतनी तपोक्री वो इसका
वो कुछ नहीं था अभी कुछ रिपोर्टेड डेड बॉडी
हाँ
रिपोर्टेड डेड बॉडी भी
तो मेरा भी नहीं आया मेरी इंटरनेशनल लेक्चरिंग इंडियन लेक्चरिंग कितनी आया
वो किलो ज़्यादा करते हैं आज के
नहीं वैसे दोनों बच्चे चले गए बच्चे डालेंगे तो यहाँ से
नहीं पड़ा
Good morning, guys. We are very happy to see you all here and like to thank Luthra Law Office for sending their elite team here consisting of our respected G.R. Bhatia ji, Arjun Nihal Singh, Manav Gupta, and Sanyam Juneja. We are about to start the event, but before that, as you all know, we have lost our dear Mr. A.K. Pandey. So he was a very dear colleague to us, a big advisor, senior vice president of our association, and was an invaluable asset to our association and entire IT fraternity. The vacuum created by his loss can never be fulfilled, and in his respect, I would like to request here that we will all observe a 1 minute silence. We can all stand up and show our respect to him. Thank you, guys. Pandeyji, you will be always missed. Now we are starting our event, and we would like to thank FITA, the Federation of All India IT Association, and special thanks to Mr. Devesh Rastogi, the president of FITA, and Mr. Naveen Gupta, who is the secretary, for promoting and supporting this event, Pan India in IT Fraternity. I would like to share that our association's elections are due in this March 25, and we propose to conduct these elections in the first week of March, about prior to 1 week before Holi. We also welcome Mr. Swapan Roy, our Dada, for supporting this event. He is always a big advisor, a very dear friend, and always with us everywhere whenever we need him, and his assistance and advisory is always available. He was also instrumental in, making our banners, and all this event is now online on YouTube and Facebook and Insta and everywhere. So I would like to thank you, Dada. Thank you so much. And I would like to ask Mr. Puneet Singhal to come here and give an opening note and brief us about a little bit about this event and what this meant for us. And please welcome Mr. Puneet Singhal, our president.
Good evening, guys. I think we are meeting after a very long time, and we are privileged that we have such senior lawyers amongst us. Mr. Bhatia, who's got so much experience behind him. Then we have Arjun. Then we have Sanyam, and we have Mr. Gupta. And we welcome them all. So firstly, we would want to honor them, and I will request Mr. Manoj and Mr. Kuldeep to honor Mr. Bhatia with a shawl. I'll now request Mr. Pramod Rajpal and Mr. Hemant Grover to honor Arjun Nihal Singh. I'll now request Mr. Pramod Rajpal and Mr. Hemant Grover to honor Arjun Nihal Singh.
ये तो आए तो भाई
I would now like to invite Mr. Swapan Roy to honor Mr. Sanyam Juneja. Now I'll invite Mr. Raj Kumar and Mr. Khandelwal to honor Mr. Mukesh Gupta, Maram Gupta, sorry. I'm sorry. Huh? Now I'll invite Mr. Raj Kumar. Come, ma'am, come. Please join us. To honor Mr. Mukesh Gupta. We welcome Madam Archana from DQ channel. She has just joined us. Manoj, can you just guide her? We welcome Madam Archana from DQ channel. She has just joined us. So just briefly, I would like to touch upon a few things. One is we wanted to take this association. We have associate members from across the country now, and to take this forward and make our association more generic, I think we'll soon be proposing changing our association name to get out of this media thing. You know, people associate us with only media. So we will soon want to go in for this change, that we might change our name to a more pan-India presence and more towards IT. And we might have branch offices. Yes. So this is one agenda in the new year. So I think we'll all take this forward to grow more. Another thing is, now coming back to the subject today, this is one area which is, basically it's understanding and complying with Indian competition law. This is, I think, very new to most of us, because we feel like these are all for multinationals and other people, and how will we be affected? But, sometimes people who are associated with multinationals or with bigger companies, or even elsewhere, I don't know, in different circumstances, people can be on the wrong side of law without even realizing what they are doing. So this law is known as antitrust law globally. I think in our country only they call it competition law or something. Mostly it's addressed as antitrust law. So without wasting more time, I think we should be handing over the stage, etc., to Mr. Bhatia and Mr. Arjun. I request them to please come here and conduct the affairs. Thank you. So without wasting more time, I think we should be handing over stage, etc., to Mr. Bhatia and Mr. Arjun. I request them to please come here and conduct the affairs. Thank you.
Okay, whatever you wish.
First slide. Good evening, everybody. Thank you for having us here. Very briefly, we will introduce the firm. We are from Luthra and Luthra Law Offices, India. We are a full-service law firm with over 300 lawyers, with over 60 partners. We specialize in every walk of the law, from corporate, commercial, white-collar, litigation, criminal law, competition law, which we will just brief you about. Today, we have Mr. Bhatia with us, who is the competition partner and head of Luthra and Luthra Law Offices. He is the ex-Director General of the CCI. He was instrumental in drafting of the Competition Act. He's been trained in Japan. He has specialized in this field since the very beginning. He was associated with the Monopolies and Restrictive Trade Practices Commission, the MRTP Commission. He's been there with the CCI. Then he was introduced as a partner in the law firm, and since then he has been heading the competition team. He practices everywhere in every forum, from the CCI to the National Company Law Appellate Tribunal, High Courts, and the Supreme Court. I am Arjun Nihal Singh. I work with Mr. Bhatia. I'm also a partner in the competition team. I assist Mr. Bhatia with every matter, and I also practice at the CCI, the NCLAT, as well as the Supreme Court of India. This presentation today is very crucial and important because it is something about a new law. I will not say new law, but it came into existence in 2009. So people are very unaware about this law, but the ramifications, the consequences of violation are humongous. Is why we are here today to brief you, to explain you the law, explain you our position, and give you a general idea about how the CCI works. Now I hand over the podium to Mr. Bhatia.
Good evening, and many thanks for the very lovable welcome. The presentation today evening is dedicated to competition law. Friends, kindly remember, you are not only a distributor and a dealer and in business, you are a consumer, you are a service provider, you are an enlightened citizen of the country. Hence, having awareness of the provisions of competition law impacts your life, impacts your day-to-day working. So it is, if competition is not there, we are all going to be killed. And kindly remember, each one of us is competing with the other one. Arjun Nihal Singh is competing with me because he wants to occupy my position. So I always endeavor to occupy a higher pedestal. That should be the spirit, and that's what competition law is. So kindly, today you remember not yourself only as a dealer, but as enlightened citizen, as enlightened consumer, as enlightened parents and grandparents. Kindly be attentive to what I am going to tell you, that how much competition law impacts my and yours, your nephew, your niece, your neighbors, your cousins' lifestyle. Competition reduces the prices of goods. Sir, you remember that 30 years back, it was just not possible for a mediocre person like me to travel by air. And we used to tell our friends and relatives, today I have traveled by air. How much benign it has become because of competition in the civil aviation industry. It is competition which improves the quality. You know it, MTNL used to be the dominant player in providing landline service to us. Today they have been overtaken by mobile operators. So improved quality of telecommunication service is made available to you as consumer. It is competition which boosts the choice. Some of you faces which I am seeing, they must be remembering that in Delhi, there used to be only one supplier of milk, Delhi Milk Scheme. And for obtaining a bottle of a milk, you necessarily need to have an 80-year-old person who can keep bag at the milk booth to fetch one bottle. Today we have got public sector undertaking, we have got Mother Dairy, we have got Nanak Milk, we have got a host of players. Britannia is there to supply milk to us. And if I happen to be a partner or Arjun happens to be a partner and I relieve him at 11 o'clock in the night after finishing his task, he can have a pouch of milk of his choice, thanks to competition. It is competition which promotes efficiency. We don't have competition in the post office services. That's why you find a person who has not even taken a bath, you find them on the counter. You know it that how much in every walk of life you will find anti-competitive practices, sir. We are taking petrol and diesel from three main companies, Indian Oil, Bharat Petroleum, Hindustan Petroleum. All of them are they are buying crude oil from different suppliers. Their logistic cost is different, plant life is different, refinery capacity is different. But when Mr. Singh goes to a Pitampura dispensing pump, he finds that whether I buy from Indian Oil or from Bharat Petroleum or from Hindustan Petroleum, price happens to be the same. And that's why there is no pressure of competition on the dispenser, and that's why when I buy a petrol of 4,000 rupees, even he doesn't give me a smile. Why? Because pressure of competition is not there. It is competition which punishes the laggards. If you are not efficient, you will be punished and you will be taken in the market. So in case we want to have availability of goods in abundance of acceptable quality at affordable price, we need to have competition. So, sir, we have to live in competition era. The moment you get up from the bed, you start talk of only competition. Admission in nursery schools, right up to career, right up to business which you are doing. So I would understand, you can't scuttle competition, you have to live with competition. And kindly remember, for 99.9% of your requirements, you are a consumer, and only in 1% of your business, you are owner of your business. So you have to depend upon competition in the markets. I will not, because we have started late, though I will try to catch up like Rajdhani train, but still it will be difficult. So kindly understand that there are three major components of the competition law. One is anti-competitive agreement. And as you know, if I happen to be a manufacturer and I am selling my goods, I need dealer, I need distributor, because it is beyond my capacity to enter into the market to sell the product. So since I don't have capability and capacity to market those products, I need the services of distributor and dealers. But what I do, if I happen to be a dominant player, I will impose certain restrictions on the dealers, on the distributor, and the restriction will be, you will exclusively deal in my product. You will not keep competing product in your showroom. If this is the condition, sir, worldwide, globally, this is objectionable. If the manufacturer happens to have huge market share in the market. दूसरा है, in case you happen to be a dominant player, because you are the only player who has got that capacity to provide that service, then it is called abusive conduct you will indulge. And sir, you all know it. In the traffic rules, there is a rule, if you are in a drunken state of affairs, please don't drive the vehicle. So is the case in competition law. If you are intoxicated with huge market share, huge assets, huge clout of the market, then you are not expected to abuse your dominance, sir. I will take only 1 minute in explaining you a case of DLF. I am a resident of Gurgaon, and DLF, in terms of the value of the apartment ranging between 1.75 crore to 2.5 crore in Gurgaon. It sold highest number of the flats. It is in real estate business for last 70 years. It holds land which is of a premium quality. Based on this, the Competition Commission of India assessed that DLF in Gurgaon geography, you are dominant player. And now I will tell you the flat buyer terms and condition. Sir, you all, the audience will be astonished. The first terms and condition is, Mr. So-and-so, if you pay 100% consideration toward the flat, yet it is the discretion of DLF to give you flat or not. You have paid 100% consideration. DLF arms itself with the right to give you or not to give you. Second condition is that if there is a delay on the part of DLF, DLF will pay you 6%. If there is a delay on the part of EMI by the allottee, it will pay you 18%. He will be charged 18%. Third is that whatever is the super area, that is final, no appeal, no dalil. That is the condition of DLF. If because of delay, there is incremental increase in the price of cement and all those things which go into making of a flat, it will be paid by the allottee and DLF will not bear it. So imagine 4 conditions on you. What a abusive conduct, and that's why DLF was hauled up on these abusive terms and conditions in the flat buyer agreement. Another concept is combinations. Combination is when you cannot meet and compete with the competitor, then they try to marry the competitor. It is just like as happened when Mughals found that it is very difficult to beat and compete with Rajputs. They thought of marrying in those families. So this is the culture in corporate also. When you are unable to meet and compete with a competitor, you try to acquire control, you try to buy their shares, you try to somehow try to have friendship, merger or marriage with your competitor. That is combination, and those are also worldwide looked upon by the competition authorities. You have recently seen PVR and Inox, the 2 major cinema exhibiting companies, they have merged. And I am a resident of Gurgaon, and every cinema hall is now owned by PVR. So my choice is not there. Samosa I will get thanda, because they will not bother. So we need to have competition in all walks of life. And kindly remember, the moment the family is blessed with second child, the first child starts getting the heat of competition because of sharing of love and affection of grandparents, parents, and uncles and aunties. So is the case exactly in industry. The moment another new player came, like in mobile phone, Reliance Jio entered, it shook, so it shaken the Airtel and Vodafone people. Now Reliance has acquired huge market share, and perhaps if they start selling below the cost of production, the competition authority will now take action against Reliance. Now coming on this, what are the powers? This is very important for you. I have given you a background of why competition is required, what are the benefits. We can't live without competition. But you as a business entity should know that what are the powers. Power is very huge. Under the MRTP Act, only cease and desist order was passed. That means don't do it, don't repeat it. But now this law has now been replaced, and in trend with the competition law, global competition law, the Competition Commission of India, which is the sole authority to implement competition law, is now vested with the power that in case there is cartelization amongst the various manufacturer and suppliers, the penalty is 10% of your turnover as you have shown in your balance sheet. So why in the balance sheet? So that you cannot tinker with the quantum of your turnover. Whatever you have already shown, and when you prepare your balance sheet, you file a copy with the income tax department, you file a copy with the registrar of company. If it is a registered company. So you file at various government offices. So you cannot manipulate, you can't tinker with it, and penalty is 10% of the turnover. And in case the cartel has continued for 10 years, 10 years turnover will be taken into account. So it's a huge penalty, and its penalty is not only on the artificial person, because company is an artificial entity. उस artificial entity के पीछे कोई natural आदमी होता है. So it is not the car which hits another car, it is the driver who is responsible. Hence, those who are running the business, they are equally responsible. And in case you have shown, whatever you have shown your income, in your income tax return, up to 10% of that income can be taken as a penalty by the Competition Commission of India. And kindly remember that our Competition Authority of India has now entered into MOU with all matured trading partners like Japan, like US, like Australia, like European Union. So in case your company with whom you are dealing is US based, don't be under impression that मैं US based company हूँ और मैं बच जाऊँगी. If you are doing business in India, law is very clear, you are subject to the jurisdiction of the Competition Commission of India. Lufthansa, a German-based company, can't take plea that I am German-registered company, I have nothing to do in India. The competition authority will say you are doing business in India. If you are carrying passengers from India or to India, then you are doing business in India. And in case you are indulging either in anti-competitive practices or abuse of dominance, you are liable for penalty under Indian competition law. Sir, next. I think time is limited, so I will give you two types of agreements, horizontal and verticals. If HP, Canon and Epson, they are in the same line of business, they are making printers, if they enter into any kind of arrangement, agreement, fixing of price, allocation of market, allocation of customer or bid rigging, this is horizontal. Here the relationship is that A is competitor to B and B is competitor to C. But in case horizontal player, a raw material supplier enter into an agreement with manufacturer, with wholesaler or retailer, these are called vertical agreements. In vertical agreement, the relationship is generally that of buyer and seller. Manufacturer sell to wholesaler, wholesaler sell to retailer. So where there is a relationship of buyer and seller, these are called vertical agreements, and penalty in case of vertical agreement is up to 10% of average turnover of last 3 years. Kindly remember, up to 10% of average turnover of 3 years. So far as horizontal agreements are concerned, penalty is up to 10% of the total turnover of all those years in which you cartelized. So if ACC, Ambuja and L&T and JP Cement, they cartelize on the price of cement bag, the penalty will be on turnover of all the grey cement bag for all the years put together. But in case JK Cement enters into some vertical restraints with the dealer, then it will be only 10% of the average turnover of last 3 years. That is the difference between. So I come to the major slide, and thereafter Arjun will explain you the law provision. Sir, if you are fixing the price, if you are limiting the production, for example, MRF, Apollo, JK Tire, Seat Tire, 4 people, they attend a meeting in a hotel and they decide कि कार टायर की जो प्रोडक्शन है हम 10% घटा देते हैं. With the result, what will happen if they reduce the production in connivance with, in collusion with each other, then the price of car tire will go up. So in collusion with competitor, if you are trying to limit the production or limit the supply, it will amount to cartelization and penalty will be huge. Similarly, if you decide that ACC, Ambuja, JK Cement, JP Cement, they join hand together and they decide hereafter I will sell a 52 kg grey cement bag for 400 rupees, it is a case of cartelization because they have decided not to compete on price. You have to compete on price. That is the requirement. Allocation of customer. One tire company says, I will sell in Punjab. Another says, I will sell in Haryana. Third says, I will sell in Uttarakhand. Fourth, in Himachal Pradesh. This is allocation of, geographical allocation of market. If tire company decides that I will sell to Maruti, I will sell to Honda, another company will sell in the replacement market in Karol Bagh, this is allocation of customers. Original equipment manufacturer and replacement market are altogether different. And incidentally, let me tell you that tires are sold at 30% at a lower price than the price at which I get in Karol Bagh area. Why? Because Maruti, Honda, Hyundai, they have got so much capability. अगर टायर कंपनी उनके ऊपर अब्यूज़ करती है तो वो कहता है मैं अपना ही टायर प्लांट लगा लेता हूँ, लेकिन पुनीत जी नहीं लगा सकते. He is an innocent, unaware customer without any power, and hence he is a victim of anti-competitive practices of tire companies. Vertical agreements मैंने थोड़ा idea दिया because we have got to finish lot of things. Now bid rigging is extremely important, and you people, some of you may be aware that some of the companies are facing problem. Dealers are also facing problem because of bid rigging. And in bid rigging, why? Because it's the most comprehensive objectionable trade practice. When I want to buy 1 lakh tires or 1 lakh bag of cement, and you as manufacturer, you collude while giving your bids, you are either rigging the bid or you are scuttling the bid process, or you are either giving nominal bids. अगर आप inflated price देंगे तो that means your bid is of no consequence, it has got no relevance because it can't be treated as L1. So invariably inflated bids are given only with a view to scuttle the competitive bid processing system, and hence worldwide, and so is the case in India, objectionable practice under the competition law. लेकिन कहाँ कहाँ bid rigging की ज़्यादा likelihood है, उसकी indication क्या होती हैं? When there are small number of bidders, and you know many times manufacturer controls how many people will give their bids. Little or no entry is there. Oligopolistic market means very few suppliers are there. Repetitive bidding is there. Identical products are there. Few substitutes are available. When few substitutes are available, like for example, if you are maker of a blood pressure medicine, and there are very few manufacturers who manufacture blood pressure medicines, so you will indulge in a practice of limiting the production so that the price of blood pressure medicine can be formed up. There are so many cases, but I will, sir, what is the time available to me? Please continue. Okay. So, sir, whenever you enter into an agreement, you become an enlightened dealer. You must ensure, you must speak, must give a signal that you are fully aware of antitrust law. And it is my experience, sir, if you, the more awareness you show, that is what is the objective of today's training program, sir. More awareness you show, the other person will start tumbling. कि यार ये तो पूरा कानून जानता है, इसको it is very difficult. So don't be an innocent dealer. Don't be an unaware, ignorant dealer. Become conscious of your rights. So my major intent is to come here and to share with you to understand your right. No manufacturer can insist exclusive dealings. No manufacturer can ask you that your territory of operation will be this much. At least show your anger, show your reaction. That, sir, I understand this is not permissible under the competition law. So you can also form your association and agitate at a collective level also. But at the same time, you have to understand that you are a business entity, and if in case you are taking collective action, it ought not fall within the trap of the cartel also. So you have to be cautious also. So trade association is absolutely advisable, but at the same time, trade association also has to be conscious of the fact that it should not encroach upon the area of cartelization. Sir, I will give you few example of, and जो day to day आप देखते होंगे, chemist and druggist association. Sir, आप different colonies में रहते हैं. Sir, you will astonished to know, pharma company इतनी powerful company है like Abbott, Roche and all those things. उनके ऊपर chemist and druggist association, वो इतनी powerful body है, वो ये कहती है, ए मिस्टर एबर्ट, you cannot appoint another chemist without my permission. You have to get no objection certificate from me. And so chemist and druggist, and what is happening, if in Gurgaon particular area, if new chemist is not allowed to operate or not allowed to be set up by a company, first Abbott is a company, Pfizer is a company, Mankind is a company, it has got a fundamental right to do its business. Chemist and druggist association come in the way and they tell you this you can do, this you can't do. So this is an objectionable practice, and chemists and druggists are facing problems haywire under competition law. Worldwide they have faced, and now in India also, and they have been substantially tamed. Sir, Cement Manufacturer Association, cement is an interesting case, sir. You will astonish to know that Cement Manufacturer Association and 11 cement makers, which includes ACC, Ambuja, they have been punished 6,300 crore, which is 0.5 times of the profits of the cement company, and Cement Manufacturer Association has been imposed penalty of 85 lakh rupees for supporting, for blessing, for assisting, for facilitating cartelization amongst the cement companies or amongst its members. So association can also be punished and members can also be punished. Sir, you will astonish to know that at the platform of association, all cement manufacturers were providing data, how much ACC is producing, how much it is dispatching, what is its expansion plan or business plan, how they are fixing the price. So prices were also regulated, production was also regulated by the association, dispatches and supplies were also regulated, even capacity utilization was also regulated by the association. So association and its members were found to be fully in cartelization, and the victims were all those who were buying cement for construction of their houses and flats. So cartel is, sir, absolutely prohibited, sir. Now another important part is, sir, information exchange. Kindly understand WhatsApp, emails, all these are admissible evidences. Today I am in Anand Niketan club. Now I cannot, even whomsoever I engage, even if I engage Abhishek Singhvi, nobody can deny that I was not present here. There are attendance register, maybe when I entered, there may be camera at the entrance and my face must have been captured. So kindly appreciate that in a current scenario of investigation, it is very difficult, extremely difficult. First, my mobile itself, this becomes helpful to the investigating arm because it contains WhatsApp messages, tower signals are there, where I am, at how much time I spent there. Everything is, evidence can be retrieved from my mobile phone. So kindly don't be under impression. And if you are sending a mail and you are saying, please read it and destroy it, it will not help you, sir, because your email remains on the server. It can be retrieved. And incidentally, Director General of Competition Commission is empowered. He will issue a notice to Gmail or Yahoo Mail or whatever mails they are there to give the complete record, and he will get the complete record. So don't be under impression कि आपकी ईमेल जो है वो छुप जाएगी, आपका ऑफिशियल आप मेल से ना भेज के आप पर्सनल ईमेल से भेज देते हैं. तो now, and we are handling one matter, sir, where my name will be kept as Paris, my friend's name will be London, and third name will be New York. And so they were sending mails like this, New York @ so and so, so and so. But they have been found, they have, investigator has found who is New York and who is Paris and who is London. So all these things are now retrievable, possible, and they are admissible evidences. Sir, information exchange among competitor is a deemed cartel. सर, आप 4 लोग बैठे हैं, अगर चारों लोगों का मुझे पता लग जाए कि आपके जेब में कितने कितने पैसे हैं, तो मैं अपनी बिजनेस स्ट्रेटजी कर सकता हूँ. सो थ्रू द प्रोसेस ऑफ एसोसिएशन और अदरवाइज इंडिपेंडेंटली, इफ यू आर एंगेजिंग योर सेल्फ इन इंफॉर्मेशन एक्सचेंज, प्लीज डोंट बी अंडर इम्प्रेशन दैट इज ए डीम्ड कार्टेल एंड यू विल बी कॉट अंडर द कॉम्पिटिशन लॉ. Sir, this display. सर, अगर आप कॉम्पिटिटर से प्राइस इंक्रीज, टाइमिंग ऑफ प्राइस इंक्रीज, कॉम्पिटिटर से बातचीत करते हैं, डोंट बी अंडर इम्प्रेशन कि मैं टेलीफोन पे बात कर रहा हूँ या ईमेल कर रहा हूँ या व्हाट्सएप मैसेज कर रहा हूँ. दिस इज नॉट परमिसिबल, सर. एंड सर, इन यूरोप, सर, if your competitor is entering into an elevator, guidance is that please leave that elevator. Because if you are found to be at the same time in the same elevator, perception will be, you will be required to defend yourself. So once, if in case you are going to meet a competitor, please keep a record. Sir, I am going to meet a competitor, and the intention is not to talk about business but to invite on a function at my family. If you are keeping a record, if you are sending an email and that email of 22, if it is unearthed in 24, that can be a great defense for you. So create an evidence when you are meeting a competitor. Yes. Sir, this is not permissible practice. If you are allocating the territory, the answer is, okay, East District is our territory, promise to us that you will not sell your product in our territory. Allocation of territory is not permissible, sir. Next, sir. This is also, sir, not permissible practice, sir. सर, अब आप वो दिखा दो, लीनियंसी वाली, वो कार्टेल वाली है स्लाइड जो सीसीआई की है, वो दिखाओ. हाँ, लीनियंसी. Sir, in case you have entered into cartel and then you are very prudent and wise and you inform the CCI at the earliest, informing that sorry that I have committed mistake, I have cartelized, you become a leniency applicant.
Recording stopped.
So leniency applicant get a concessional treatment so far as penalty is concerned.
So, what have you decided?
You mean bid rigging? Yes, of course.
That's the
इसको
spirit.
दोबारा से करिए
I'll call you
पहले से
later.
करिए
Okay.
शुरू से करिए वॉइस तेज करिए
So, what have you decided?
We shall decide the bid together.
You mean bid rigging?
This is not the first time. This will be profitable to all of us. Don't you need work?
Yes, of course.
That's the spirit. I'll call you later.
Okay.
Good morning, sir.
Good morning.
Good morning, sir. Sir, please sign.
Why are they looking at me like this?
If you do such things in business, people will be suspicious of you.
How everyone came to know about bid rigging so soon?
How long can you hide such things? Someday or the other, people will get to know.
Oh, I'll be in trouble. What should I do?
Leniency provisions, have you heard of that?
Do not hide contravention of competition law. Share information with the Competition Commission of India and get penalty waiver. For more information, log on to www.cci.gov.in.
सेम नाउ लीनियंसी ना थोड़ी स्लाइड छोड़ दो लीनियंसी पे नहीं वो पिक्चर वाली दिखा और आगे नहीं वो पिक्चर है ना हाँ यस सर दिस इज द एडवांटेज ऑफ कंप्लायंस पेटीएम सफर्ड 1000 करोड़ फाइन बिकॉज ऑफ नॉन कंप्लायंस इन्होंने आरबीआई लॉ जो भी रेलेवेंट लॉ था उसकी कंप्लायंस नहीं की एंड सी द फेस ऑफ विजय कुमार शर्मा मैनेजिंग डायरेक्टर ऑफ पेटीएम नेक्स्ट स्लाइड बेटा Sir, compliance program is like lipid profile. Once I am above 45, I am expected to be very sure what is my blood pressure, what is my cholesterol level, what is my glucose level. I hope that after my presentation you must have become a little bit enlightened. How relevant it is. Imagine a situation, you stay in Punjabi Bagh and the three principals of Jindal School, Hansraj Model School, whatever good public schools are there, their three principals meet and they decide अगर किसी के बच्चे के 10th क्लास में 80% से कम मार्क्स आए होंगे उस बच्चे को हम एडमिशन नहीं देंगे. Now you are a resident of Punjabi Bagh, you can't admit your child to Vasant Kunj, you can't admit to any other school, you need Punjabi Bagh school. And three principals decided, and it is an educational services which is being rendered for consideration. So how much victim you are? Sir, yes. So sir, if you are having a compliance program, the Competition Commission has put in public domain, that too after 11 years, 2009 as Arjun mentioned that competition law came into force, despite so many times order by the Supreme Court, the Competition Commission was not coming up with the guidelines to inform the public what will be the basis of determining penalty on the delinquent companies and delinquent individuals. It is only now, sir, and kindly see, now guidelines clearly says that in case you are having a compliance program across organization, it will be one of the mitigating factor which Commission has to look into while determining the quantum of penalty. And this was one of the major objects, apart from sensitizing you, creating awareness, also that it is beneficial so far as determination of penalty is concerned. Now I will give my mic to my colleague who has worked very hard, and whatever I have spoken, credit goes to Arjun, Manav and Sanyam.
Thank you, sir. I wouldn't be able to explain like Mr. Bhatia did because his experience speaks. However, what I would like to do is give you real life examples of how we work and what we do so that understanding this law becomes easier. Competition law sounds very complex. Criminal law name sounds easy. Civil law, specific performance sounds easy, but competition law sounds ye hai kya cheez. So I think certain live examples of the cases that we work on will be very helpful to the audience here to understand more about the law. Like Mr. Bhatia had briefed everybody in this room about Section 3 of the Act, which is anti-competitive agreements, cartels, bid rigging. I will attempt to brief everybody about another provision, which is very, very important, called abuse of dominance. What is abuse of dominance? It doesn't sound like a legal term at all. Being dominant is not bad. But once you are dominant in the market, abusing that position is very bad. That you cannot do. And if you do that, then you will be penalized. Not only your company, but also the individuals behind that company. Abuse of dominance is such a provision. It is a very conduct-based provision. Your conduct is looked at. How you operate yourself in the market. It is not that you have you violate the law simply by doing something. No, it is a practice that you do over a period of time, not one instance, but multiple instances together, which lead to violation of this law. How this law works is the powers of CCI, like Mr. Bhatia explained, there is no complaint mechanism. All one needs to do is file one letter with the CCI saying, we understand or we believe this company has violated the law. That will set the CCI in motion. The CCI will order an investigation, will appoint an investigator to conduct the investigation. The DG, which is the investigator, will come knocking at your door like the income tax officers. They will come, seize your goods, your mobiles. They will take your deposition there and then. They will prepare a report. They will sit at your office for 2 days. They will prepare a report, submit it to the CCI. CCI will send that report to you. You will give your comments. If the CCI feels no case is made out, they will let you go. If the CCI feels that a case is made out, then you will be penalized. Your officers will be penalized. The MD of the company will be penalized. There is a new provision which has come, like the Income Tax Act. To file an appeal, you have to pre-deposit the penalty. In this law, the penalties are so high that every company, every MNC is extremely scared of the consequences of the law. Like DLF. DLF, CCI imposed a penalty of 630 crores on DLF. The cement company, 7,000 crores. Tire manufacturer cartel, the cumulative penalty was 1,700 crores. Now who can pay this penalty? Now to file an appeal, aap 1,000 crore ka 25% you'll have to deposit first to get your appeal admitted. So compliance with this law is very, very important. Section 3, which talks about anti-competitive agreements, Mr. Bhatia, which he explained about, is also conduct-based. We will give you an example of a recent case that we did for a statutory authority, wherein we filed an information with the CCI saying that I have floated a particular tender. In that tender, there were only 2 participants. I have floated 7 tenders. Now in those 7 tenders, in one tender, 1 party participates, other person participates, third tender, 1 party participates, fourth tender, the other party. So there was a pattern. I went and informed the commission that this is what's happening. This other person who is putting dummy bids, cover bids, he is technically disqualified, but he's still putting those bids. I have a feeling that there is some cartelization happening. CCI has opened up an investigation. Now those parties have just been raided. Investigation is going on. So this is an example of Section 3 works. Now, Mr. Bhatia had explained vertical agreements. What are vertical agreements? For example, a Zomato or a, let's say, the hottest case right now with the CCI is the Flipkart and Amazon matter. What Flipkart and Amazon used to do is, Flipkart used to appoint some sellers who they used to call preferred sellers. Now these preferred sellers used to be their own men who used to be selling on the website of Flipkart. Flipkart used to say, okay seller, I will give you discount of 10,000 rupees, you sell these mobile phones. I will put you on top. You will be the preferred seller, you will appear, whenever somebody wants to buy a mobile phone, you will appear as number 1 there. So, as a consumer, when I go on the Flipkart app, I want to buy an Apple iPhone for myself. I go there. First seller is XYZ. This XYZ is Flipkart's man. Now, a person like Sayam who also wants to sell mobile phones on Flipkart says, I am not being able to come on top. How should I get my listing to number 1? How should I get a better price than him? He's selling an iPhone for 1,10,000. My cost is 1,20,000. What Flipkart, Amazon used to do is they used to give preferential treatment. They used to say, okay, you bear this much expense. You give so much discount, I will reimburse you. That is called a vertical agreement, which is prohibited under law. Now I come to abuse of dominance. Abuse of dominance. Like I said, having market share is not bad at all. You can be 100% dominant. But when you indulge in certain activities or certain conducts is when it is bad. For example, I will break it down into very simple terms. Exclusionary and exploitative. Now you will ask me a question, what do you mean by exclusionary? What do you mean by exploitative? Exploitative abuse. I enter into a builder-buyer agreement with DLF. DLF, once I sign, I pay earnest money. I pay 1 crore. I have to pay 2 crores more. My building is getting made. Bel Air ban rahi hai. I say that, okay, I want a higher floor. DLF says, okay, no problem, we'll give you a higher floor. Now what DLF does is, there's an inordinate delay. If I don't pay them money, they will charge me penal interest. But if they don't deliver on time, they will give me nothing. If the DLF tells me that I will give you an apartment on the 10th floor, the building will be of 20 floors. They construct 30 floors. What can I do as a consumer? Nothing. I can only cry. I will say, DLF, what did you do? Now, the swimming pool that you have made or the lift that you have made is for 5,000 residents. Now you're putting 10 more extra floors. There will be 7,000 people. Where will parking be? DLF said, nothing doing. I will do it. You can't do anything. This Bel Air Association then went to the CCI. CCI said, okay, I will investigate. And in this case, the CCI imposed a 630 crore rupee penalty. The case is still pending in the Supreme Court and DLF has deposited 100% money with the Supreme Court. 630 crores is what they've deposited. It is lying with the Supreme Court till date. This is a type of exploitative abuse. When you enter into an agreement, there is no way out. They will say, okay, we will forfeit your money. That is an exploitative agreement. Exploitative abuse. Another example is exclusionary abuse. Now what is exclusionary abuse? Where one competitor does not let another entity come in the market. I will give you live examples of the cases that we are doing. Roche is a MNC. We all know about Roche. It's a global pharmaceutical company. They manufacture a blockbuster cancer drug for breast cancer. They have the patent for it. They say, nobody will enter the market. I am the dominant person. I will not license this to anybody. India is known for generic medicines. Mankind, Biocon. They all manufacture generic versions. Generic version is to reverse engineer and to create a generic, a cheaper version of that medicine, but with the same efficiency and efficacy. Biocon tried to enter the market. They launched a competing product to Roche's product. Roche's product was priced at 1 lakh rupees for one dose. Biocon's product was priced at 10,000 rupees a dose, which was helping the common people. What Roche started doing was, Roche started going to every hospital, every government body which procures medicines, and started saying, Biocon's drugs are sham, they don't have approvals, they are not approved properly. If your patients have these medicines, their efficiency has not been tested, their efficacy has not been tested, so do not procure them. Biocon started losing the market. Biocon said, how can Roche do this? In fact, Roche went and filed civil suits against Biocon. They said, Biocon ko to main rok ke rahunga. And they were successful to a certain level. However, Biocon went to the CCI and said that this is what Roche is doing. They are not letting me enter the market. They are denying me market access. They are dominant in the market. They hold 80% market share. So please investigate them. The CCI started an investigation against Roche. And today is a day where Roche has said, I am ready to settle the matter. Similarly, JCB. JCB, as we all know, manufactures bulldozers. Bull Machines was a very small Indian company, whereas JCB is an international MNC. Bull Machines launched a very similar product to a JCB bulldozer. And they had, at like an auto expo, they said, we will manufacture and launch this product in full throttle. India will see this product being launched and we will become a global player. But JCB, what they did was, they went to the Delhi High Court and wahan se they got an injunction order saying that Bull Machine has copied my product, so please injunct them from launching. Delhi High Court saw merit. They said, okay, we will stop Bull Machines. The day Bull Machines had to launch at the show, they were stopped from launching. Local commissioners were appointed. They said, sorry, Bull Machines, you cannot do that. Bull Machines went and filed a complaint in the CCI. CCI started investigating JCB. The CCI then raided JCB's premises. Ultimately, the matter got settled. However, JCB was investigated for such exclusionary abuses. So this is the concept of abuse of dominance in the Act. Sayam, can we go to the next slide after abuse of dominance? We can go to the next one also. Next. We can go to the next, I've given these examples. Search and seizure. Yeah, this is important. So as I had mentioned, the CCI has the power of coming to your doorstep like the income tax authorities. This concept in competition law is known as dawn raids. Recently, I don't know if all of you have read a report saying that Amazon and Flipkart were raided. The raids went on for approximately 4 days at each premises. Generally, such raids happen only in cartel cases, in bid rigging cases, where there is an element of secrecy. Because bid rigging, whenever it takes place, it will take place behind closed doors. There will be no mention about this happening. It will happen, there will be no document, there will be nothing. Now, slowly and gradually, cartelizing has changed. Initially, there used to be emails. Now, there is a different mode of cartelizing. Cartelizing is happening through driver mobile phones. Cartelizing is happening through signals. To prevent this, the DG has this power of coming to your premises. However, before they come to your premises, they have to take authorization from the Chief Metropolitan Magistrate of Delhi, saying that they have reason to believe that there is some hanky-panky going on, and they will come in raid only after the DG, the CMM gives them permission to raid the premises. During a search and seizure operation, they can seize any and everything. They can break open locks, which has happened to us. In fact, on a lighter note, we will give you an example. We were sitting at an association's office and for a meeting in the morning on a Friday. And as soon as we entered, we sat there for tea, and the CCI people came knocking. And luckily, Mr. Bhatia was there, so he knew the investigator, so the raid went on smoothly and didn't last for 48 hours, but 24 hours, and we were in their office during that entire time. So, when this raid happens, the first thing to do is to call your legal counsel. Whoever is a part of the raid, you have to be very cooperative with the investigative agency. You have to tell them that, okay, please sit down, we will cooperate, we will give you full assistance, we will give you all documentation. The more we give them, the better it is. After that, it is for us to defend you. But the moment we try to conceal any sort of document, not show them the phone, try to hide a phone, they are all very smart. They get their forensic experts with them. They will sit there and clone your mobile phone. You will say Wi-Fi is not working, they have their own Wi-Fi. They will have everything available with them. So, paramount rule number 1 is to cooperate. Number 2 is to call us. Same, we can go to the next slide. Correct. This is fine. Now I will take you to the recent amendments in the Act. As you're all aware, that first the law was MRTP. Under MRTP, the law wasn't very strict. Then Mr. Bhatia realized that the law isn't strict. Then he drafted the Competition Act. The Competition Act, over a point of time, it has done very well. But now the CCI has realized that no, even this act is getting obsolete. There are new ways of cartelization. So they have introduced new concepts. Initially, they used to say that an association will not be liable. Association is not an enterprise. It can't be held liable. But now, explicitly, they say that an association can be held liable. There is a concept called hub and spoke, where there is a central body which has dealers all around it. It will indulge in information exchange through its dealers. It will say, dealer, okay, this is the price. You communicate it to the other one. So, the central body with spokes, and they will cartelize like that. It's called hub and spoke model. This is enforced in the law now. Limitation period for filing. Initially, anybody could approach the CCI like criminal law. There was no limitation. But now, CCI has become cognizant. They say, no. 3 years from cause of action. So there is a limitation period now in the Act. Within 3 years. Initially, there was no limitation period. They could even information which was 10 years back could have been filed. Now that cannot happen. In fact, there is wider powers of the DG. The DG is empowered to seize all papers. First, it had to give back the papers. Now they can seize it for a longer period of time. Third parties can be deposed. In fact, the law has changed such that even in-house legal counsels do not have that protection. Even they can be called upon by the CCI if they are aware of the matter. They cannot take the plea that no, we will not come, we are legal counsels. CCI can depose even CAs today. They can say, okay, this is your company's CS or CA, I will depose them. The law permits it. Appeals. Like I had said earlier, now there is a pre-deposit. Initially what used to happen is CCI used to impose such large penalties, but nobody used to care. They used to go and file an appeal. Appeal used to go on for 3, 4, 5 years, then again to the Supreme Court, again 3, 4, 5 years. Now the law is very clear, 25% pre-deposit, otherwise no entertainment of appeal. Lesser penalty regulations. As Sir had explained earlier, leniency provisions. Now they say that, okay, if you're a leniency in suppose one cartel, you've been involved in another totally unrelated cartel also. you come and disclose that, you will get benefit of reduction in penalty up to 100%. This is a great incentive for company. It is like a race where one company tries to beat the other company to come to the CCI. In fact, these are new tactics where competitors, when they cannot eat up their competition, this is what they do. They go and file leniency. They cartelize and then go and file leniency. We have seen that happening in real life examples as well, where two competitors are surviving in the market. One is saying, okay, he's doing better than me, because of him I'm not being able to raise prices. They say, okay, this is a tender that has been floated, let's rig this. They'll rig it. Then other thing, next day that you know, the other person has gone and filed leniency. So this tool is also being used like this by companies. So it's a race. If you've cartelized, you have to consult your legal counsel. It is extremely important. Penalty guidelines, like Sir had indicated. Initially, we used to tell all our clients that a CCP, a competition compliance program, is very important. And this is just one facet of a competition law compliance program. There is much more to it as well. Now, the CCI says that if you have a competition law compliance program, it will be a mitigating factor. We will reduce your penalty. If I would have imposed a penalty of 100 rupees on you, if you have a CCP, I will impose 75 on you. So this is a benefit that the CCI says, spread awareness and reap the benefits. Sam, can you go on to the next one, please? Go to the next one, we've gone through this. Go back. Yes, we've gone through this as well. So I think these are the main facets of the Competition Act which are relevant for the audience here. It does not only end here. A CCP is very important in the aspect that every individual company, we recommend this and we say this to all our clients and well-wishers, that just by listening to us, it doesn't help. It helps if we understand your business. We sit with you, we look at your agreements. You might be in violation of the law, but you might also be a victim of the law, where a company is imposing certain conditions on you and you are unaware that you can actually tell them that no, this is a wrong condition. Please change it, please amend it. This is a violation of competition law, as Mr. Bhatia said in the very beginning. This is something only awareness can bring to you. And sir, I think if you have any closing remarks, thank you.
क्लोजिंग रिमार्क्स इज दैट जिसके आप डीलर हैं उन्होंने यूरोप और यूएस में भी यही कुछ किया एंड दे आर फेसिंग इंक्वायरी एंड दे हैव बीन डूइंग इट सिंस 2000 सो दिस विल बी आल्सो वन ऑफ द एडिशनल ग्राउंड्स अबाउट द कंडक्ट ऑफ द प्रिंसिपल कोर्ट राइट सर राइट सर आ जाओ संयम आंसर कम वेर इज मानव
Yes, thanks.
यहाँ बैठिए
So most of the principals, when they sign an agreement with us, we being their partners or dealers, whatever you call, they give us this much of big papers and do not give us an authority to change anything out of it. And if we try to raise questions, they change us. So they change us. So I mean, given the condition, what relief we have here. Either we agree to what they say, or they change us.
Sir, I think you also need to be
sign on the dotted line.
Yeah, this is what is the intent and objective of imparting training to you people.
Okay.
First, let me tell you, it's our experience. The moment you will sensitize them and you will give signal, उनकी intoxication खत्म हो जाएगी. हो जानी चाहिए. Because antitrust law worldwide, and so is the case in India, is very strict. And as I have explained, in case such kind of clauses are there, and you sensitize them, and if they do not come to sense, you can just send a postcard or an information to CCI. Sir, so what? You are I have already told you, sir, we have come here to enlighten you. Any citizen, even if you have, entered into negotiation or discussion with the party, I am your cousin, you can tell me cousin. And incidentally, one most important part is, sir, you can write your name A, B, C. It can be without any anonymous also.
Yeah, that's what I wanted to ask. We can write to them
Sir,
anonymously also.
there is a anonymous also, but instead of anonymous, sir, there is a provision of seeking confidentiality.
Okay.
If you write in your communication, sir, I am an ordinary citizen, please don't disclose my name. My name and other description or contact number should not be disclosed. So, sir, I will suggest you file two type of information. One confidential information, another non-confidential information. In confidential information, you can mention your name. In non-confidential information, you will write ABC.
There is one more event or instance wherein they give whatever documents they give, but they do not mention that you are authorized only for this product or only for this territory. That is a general agreement.
Sir, as Arjun has explained, we are not concerned with what are the formal clauses in the agreement, how they conduct their business. Even if in the agreement it is written, you are a non-exclusive dealer,
yes.
But in practice they do exclusivity, sir.
Yes, true.
So based on the over a period of time, sir, आप उसका record बना सकते हैं, and you can make out a case, sir, कहते ये हैं, करते ये. So, sir, it is not only the explicit clauses of the agreement, it is how they conduct their business.
Just to add to what Mr. Bhatia is saying, like I had explained, there is no concept of complainant here. You don't need any locus. Like in a criminal matter or a civil matter, you need locus. There is no. Once you have that agreement in your hand, even if you haven't signed it, you can still go to the CCI, and CCI is bound to act on it. So it is, and once, like Mr. Bhatia has mentioned, once you flag that this clause seems to be unfair and in violation of competition law, sir, it is our assurance, our experience, Mr. Bhatia's 40-year experience, at least my 11-year experience, that they change. Because they don't want that agreement going to anybody.
Sir,
because they know, all these MNCs know what they are dealing with. They treat you as you're unaware of the law.
And incidentally, sir, inquiry instituted in India. Kindly note, inquiry will be instituted in all countries. Because Pakistan Competition Authority, Korean Competition Authority, Japanese Competition Authority, US Competition Authority, they are all looking at Indian Competition Authority कि ये क्या कर रहे हैं. और इंसिडेंटली अगर वो रिकॉर्ड ना हो तो मैं आपको बता दूं कि जब जो 6,300 करोड़ रुपए सीमेंट पे हुआ है, पाकिस्तान कंपटीशन अथॉरिटी, जिसको कि हम थोड़ा इतना डेवलप्ड नज़र से नहीं देखते, उन्होंने ये कहा कि आप 50 लाख सैम्पलिंग करेंगे. पेनल्टी नहीं लगाई उन्होंने, 50 लाख सैम्पलिंग करेंगे क्योंकि सीमेंट इंडस्ट्री इज़ द मोस्ट हज़ार्डियस एंड पोल्यूटेड इंडस्ट्री. तो उन्होंने हर 3 महीने उनको कहा आप स्टेटमेंट लिखोगे कि कितने प्लांट लगाए, उसमें कितने सर्वाइव हुए, कितने रह गए. सो इवन हमारे कंपटीशन कमीशन के चेयरमैन कहा यार ਤੁਹਾਡੇ ਕੋਲ तो पाकिस्तानी चंगे ने. So this water trickles worldwide. That is one thing. Secondly, sir, मारुति उद्योग लिमिटेड, मारुति कार वाले जो हैं, मारुति उद्योग वाले, उन्होंने कहा कि हम डीलर के ऊपर कंट्रोल किया होता है कि इससे ज़्यादा डिस्काउंट ज़्यादा नहीं देंगे. अगर कोई डीलर देगा हम उसको आगे से कारें नहीं देंगे. हाँ जी. तो उन्होंने सर इस प्रथा को कंटिन्यू करने के लिए एक मिस्ट्री कस्टमर बनाया. मतलब मिस्ट्री कंज्यूमर बनाया। वो जाके डीलर से बात करता था, मैंने ये i10 कार लेनी है या कोई कार लेनी है, और उसको कहते थे सर वो कंपनी मना करती है, हम इससे ज़्यादा डिस्काउंट दे नहीं सकते। और अगर मिस्ट्री कंप्लेन कंज्यूमर जो है अगर आके मारुति को बताता था तो वो एक्शन लेते थे अगेंस्ट मारुति, हाँ मिस्ट्री शॉप, वो फिर उस डीलर के ऊपर एक्शन लेते थे। एंड समबडी फाइल्ड सेंट एन ईमेल to chairperson of competition commission, and Maruti has been subject to 200 crores penalty. कोई डॉक्यूमेंट्री एविडेंस नहीं है, मिस्ट्री कस्टमर ही था। सर वंस अगेन नीड इज टू एनलाइटन यू, मेक यू अवेयर।
आपने बेलियर का एक एग्जांपल दिया था जिसमें DLF को बहुत पेनल्टी लगी, क्या वो पेनल्टी लग के वो पैसा कहाँ गया, क्या कंज्यूमर के पास आया?
सर हाँ बिल्कुल सर, समय की कमी थी, आपने बिल्कुल ठीक सवाल पूछा है। सर जो पेनल्टी लगती है वो भारत सरकार के कंसोलिडेटेड फंड ऑफ इंडिया में जाती है, लेकिन स्टोरी डजंट एंड हियर। जो एग्रीव्ड कस्टमर है, जो एग्रीव्ड कंज्यूमर है, वो इसके बाद NCLAT में मुआवजे के लिए अपनी एप्लीकेशन फाइल कर सकता है। अभी मुआवजे की जो मतलब प्रथा है वो भी चालू नहीं हुई, क्योंकि मुआवजा क्लेम करने के लिए अभी उस तक केस पहुँचे नहीं, लेकिन जो मुआवजा होगा वो एग्रीव्ड कस्टमर के पॉकेट में जाएगा।
सर इन फैक्ट इन दिस DLF मैटर एक कॉम्पेंसेशन एप्लीकेशन फाइल हुई थी, बट DLF सेटल्ड। So this because they knew if they do not settle, it's going to open a floodgate.
So many
Correct.
so many complexes there.
सर हम एक अर्जुन, मैं और मानव गुप्ता ये समझाएंगे। सर फूड कॉरपोरेशन का केस जरा बताइए कि कैसे कंपनसेशन हम कर रहे हैं।
So this case was initiated in 2011 when when FCI wrote to CCI saying that they procure these aluminum phosphide tablets for their warehouses, which helps in which acts as an insecticide and a pesticide to save their stock from insects. And
सर हिंदी में बता देता हूँ, फूड कॉरपोरेशन अपने गोदामों के अंदर गेहूं को और राइस को सेफ रखने के लिए एक टैबलेट प्रोक्योर करती थी, उसको 3 कंपनियां बनाती थी। तीनों कंपनियों ने आइडेंटिकल प्राइस कोट किया उस मेडिसिन का। सर पहली बात तो ये है कि ABCD, आप 4 आदमी बैठे हैं, आपकी लोकेशन डिफरेंट है, आपकी प्लांट लाइफ डिफरेंट है, स्केल ऑफ ऑपरेशन डिफरेंट है। यू कैन बी मल्टी प्रोडक्ट कंपनी वाइल अदर जेंटलमैन कैन बी सिंगल प्रोडक्ट कंपनी। तो कॉस्ट ऑफ ऑपरेशन, कॉस्ट जो आपकी है वो डिफरेंट होनी चाहिए। अगर कॉस्ट आपकी डिफरेंट है तो हाउ यू आर कोटिंग आइडेंटिकल प्राइस। लेकिन अगर आइडेंटिकल प्राइस है तो इट गिव्स स्ट्रॉन्ग सस्पिशन कि आपने आपस में कोई कानाफूसी की हुई है। लेकिन इस केस में एक बड़ा यूनिक काम हुआ। 4 आप रीजनल मैनेजर हैं 4 कंपनियों के जिन्होंने बिड भरी थी। चारों 1:20 पे फूड कॉरपोरेशन कनॉट प्लेस के दफ्तर की रिसेप्शन पे पहुंचते हैं। एक ही आदमी उस विजिटर रजिस्टर के अंदर एंट्री करता है, एक ही आदमी लिखता है मोबाइल नंबर और ईमेल आईडी और डेजिग्नेशन कंपनी और उस आदमी का नाम, और चारों आदमी जो हैं फिर वो 3 आदमी जो हैं वो सिर्फ इनिशियल कर देते हैं। दिस एंट्री इन दी विजिटर रजिस्टर हैज़ बीन फाउंड टू बी कन्विंसिंग ग्राउंड, सर्कमस्टांशियल ग्राउंड कि आपकी तीनों की कनाइमेंस है, आप मिल बैठे हैं और आपने आइडेंटिकल प्राइस भी कोट किया है। इसके बाद अब कंपनसेशन के अंदर क्या प्रॉब्लम है वो मानव गुप्ता समझाएं।
2017 में सुप्रीम कोर्ट ने फाइनली कंफर्म किया कि ये इन्होंने बिड रिगिंग करी है, एंड दे इम्पोज्ड वेरी सिवियर पेनल्टीज ऑन ऑल 3 प्रोड्यूसर्स ऑफ दीज टैबलेट्स. In 2018, sir, we advised FCI that the case does not end here. You are liable to get compensation from the NCLT as well. So we have filed our compensation application in 2019, and and we have asked for a huge compensation running into crores of rupees. And what we have basically said is that they have, cheated the general public. FCI being a public entity, which is tasked to ensure food security of the country. They have cheated the people. They have taken crores of rupees profited from the public, and that compensation application is still pending. However, we are hopeful that it should be concluded in 2025 as soon as possible. However, the only issue that we are facing currently is that, you know, it's being FCI, it's a government entity. You know, they are not as, again, not as aware, not as proactive in helping us out. The records date back to 2011, 2010. They do not have a great record keeping. And all these compensation applications are very, very evidence specific. Yes, they require a lot of evidence, a lot of calculations. So therein comes the problem with compensation applications, and that is the reason why none of the compensation applications have been decided as of yet. But slowly we are beginning to see an improvement here, and hopefully we should get something soon.
One question. भाटिया जी, आपने एक लॉ ऑफ इक्वल जस्टिस के ऊपर एग्जांपल दिया था फॉर अ बिल्डर, जो उनकी टर्म्स होती हैं विच आर ऑलवेज फेवरेबल टू देम एंड वेरी अनफेवरेबल टू द अदर पार्टी. तो उसके लिए व्हाट डू यू एडवाइज अस, हाउ डू वी एक्ट और रिएक्ट ऑन दोज काइंड ऑफ यू नो टर्म्स, और हमें क्या करना चाहिए? व्हाट इज़ योर एडवाइस ऑन दैट?
सर, पहला तो ये है कि उस पर्टिकुलर टेरिटरी में, मान लीजिए गाज़ियाबाद डेवलपमेंट अथॉरिटी है, तो उस टेरिटरी में वो डोमिनेंट प्लेयर होना चाहिए. जैसे नोएडा के अंदर नोएडा डेवलपमेंट अथॉरिटी, उसकी सबसे ज़्यादा लैंड है, सबसे ज़्यादा प्रॉपर्टी उसने बेची हुई है, तो स्वाभाविक रूप से लगता है कि वो डोमिनेंट है. और उसकी अगर ऐसी टर्म्स एंड कंडीशंस हैं तो सर्टेनली यू कैन ब्रिंग इट टू द नोटिस ऑफ सीसीआई.
ये तो ऑलमोस्ट सभी बिल्डर्स की आप देखोगे.
नहीं, सभी बिल्डर जो हैं,
बिल्डर या जो भी, आई एम नॉट, एक बिल्डर तो एक एग्जांपल दे रहे हैं, जितने भी आपके जैसे आपने बताया डोमिनेंट प्लेयर्स या डोमिनेंट OEMs या जो भी होंगे, दे ट्राई टू डिक्टेट देयर टर्म्स टू द अदर पार्टी. दे आर ऑलवेज इन द एडवांटेज पोजीशन, यू नो.
सर, साडा एक्सपीरियंस ये रहा है, जिस तरह अर्जुन ने किया है कि एक कंपनसेशन एप्लीकेशन फाइल हुई थी DLF के खिलाफ और वो आउट ऑफ कोर्ट सेटल हो गई. उसका मतलब क्या है कि आपके वो घर आएंगे, इत्मीनान रखिए, तो फिर जब सेटल हो जाएगा तो फिर तो CCI कुछ नहीं कर रहेगा ना, आगे कोर्ट क्या कर सकती है?
नहीं,
पार्टीज
then we have to approach you people or to some authorities, or how do we?
नहीं, you have to approach, obviously, since sir it is very complex law. Prudence suggests that you should approach a lawyer.
Okay.
Who is practicing only competition law.
Yeah.
क्योंकि इस लॉ के अंदर एक ये बड़ी प्रॉब्लम है कि अगर आप आई सर्जन के पास जाते हैं, वो बड़ा क्वालिफाइड होगा, लेकिन प्रॉब्लम आपकी हार्ट की है, तो आई सर्जन विल बी ऑफ नो हेल्प.
Very well answered, sir. Thank you.
फाइल्स की
Anybody else have any question? I think we will continue along with our drinks and snacks.
नहीं सर, आप ड्रिंक शुरू करने से पहले मैं आपको ड्रिंक की भी एक एग्जांपल दे देता हूँ सर. सर, रिसेंटली परनॉड एंड वन मोर लिकर कंपनी ABF InWev, जो कि बड़ी लीडिंग लिकर कंपनीज हैं, सिंगल साहब, उन्होंने हैदराबाद के अंदर सभी जो रिटेल आउटलेट हैं उनको कंपेल किया. इन दोनों कंपनी, परनॉड का तो नाम सुना होगा आपने, और इसका AB InWev का, उन्होंने इंसिस्ट किया कि तू सिर्फ हमारा ही ब्रांड रखेगा, कोई और ब्रांड नहीं रख सकता. अगर वो ब्रांड दूसरा कोई रखेगा तो जो तेरे को हम लॉयल्टी डिस्काउंट दे रहे हैं वो हम नहीं देंगे. सो इन हैदराबाद ओनली देयर ब्रांड्स वर अवेलेबल, एंड रिसेंटली ओनली लास्ट वीक दे हैव बीन रेडेड. कंप्लेंट वाज मेड to CCI, and as Arjun mentioned, DG CCI raided all those premises, and now evidence is with the CCI that yes, exclusivity retail outlet में सिर्फ वही दो brand available थे. So this is objectionable, sir, and law will take its own course. And penalty, as we mentioned, up to 10% of the turnover as shown in the
annual turnover.
Sir?
Sir, it is just to make the topic lively, sir.
We appreciate.
सर, अगर
हेलो।
यस सर। हाँ जी।
अगर कोई प्रिंसिपल मेरे साथ एक्सक्लूसिव एग्रीमेंट करता है कि मैं सामान सिर्फ तुमको दूंगा,
हाँ।
तो सीसीआई वाले मेरे यहाँ पे आ सकते हैं? क्या मैं रिस्क पे हूँ?
सर ਤੁਸੀਂ ਤਾਂ ਉਹਦੇ ਨਾਲ ਮਿਲ ਗਏ ਹੋ ਸਰ, ਫਿਰ ਤੁਸੀਂ ਕਹਿੰਦੇ ਹੋ ਮੇਰੇ ਕੋਲ ਆ ਸਕਦੇ ਨੇ।
मतलब आ सकते हैं ना?
क्यों नहीं आ सकते? You are part of the.
Then I can go or somebody else can.
No.
They have made an exclusive arrangement.
So.
Anybody can complain against.
Sir, when some company makes, suppose Bata makes exclusive arrangement with you, I am another shopkeeper, I am another retailer, I am another wholesaler. That means there is denial of market access to me.
So
I cannot enter into the market.
2 साल बाद अगर मुझे एहसास होता है कि उन्होंने ब्रीच कर दिया है इस अरेंजमेंट को, तो मैं कोई लीगल ऑप्शन यूज करूं या सेफ खेलूं कि हम ये शांति से बैठ
नहीं,
जाएं?
आप जैसे आपकी स्वेच्छा है सर, लेकिन आपके लिए
रिस्क मुझे पता होना चाहिए।
जो भी लॉयर होगा वो ये कहेगा आई वाज एट द रिसीविंग एंड। बिटवीन द टू देयर इज नो, बोथ द एंटिटीज आर नॉट कंपेरेबल।
मैं तो ब्रीच को, वो कॉन्ट्रैक्ट के ब्रीच को
सर ਇੰਨਾ
Contract ਹੀ defective ਹੈ ਨਾ?
ਜਿਹੜਾ ਸਵਾਲ ਤੁਸੀਂ ਪੁੱਛ ਰਹੇ ਹੋ, ਕੋਰਟ ਲਗਾਉਂਦੀ ਹੈ 10 ਸਾਲ, ਮੈਨੂੰ ਤੁਸੀਂ ਕਹਿ ਰਹੇ ਹੋ ਆਨਸਰ ਦਿਓ 10 ਸੈਕਿੰਡ। ਇਟ ਡਿਪੈਂਡਸ।
ਨਹੀਂ ਇਹ ਤੇ ਕੰਟਰੈਕਟ ਹੀ ਡਿਫੈਕਟਿਵ ਨਹੀਂ ਹੈ। This is a defective contract. You can't.
हाँ sir, we have to understand sir facts and
जी बोलेंगे सर।
how evidence is brought. Yes sir, any other question?
Then people can talk to you one to one also.
या फिर आंसर ठीक थोड़ी होंगे।
नहीं, वो ठीक कह रहे हो।
Okay sir, right sir. Thank you very much. Thank you.
Thank you so much, Bhatia ji. We appreciate it. It was a wonderful session. We all thank you, Bhatia ji, and the entire team for giving us such lovely information and a very lovely and informative session. And it indeed it is. We all cherished it, and we feel we are much more aware about the laws and other things which are hurting us, and we were not aware about the same. Thank you so much. Hello. We like to mention here that हमारा अब तक जितने events, programs और get togethers हुए हैं, उन सब की pictures को हमने digitize कराया है और वो अभी हम यहाँ पर चला रहे हैं. I think you all will cherish them. Enjoy the moments.
I can